All right, good morning.
Good morning, Your Honor.
Mr. Weber, you are here for the appellant. Would you like to reserve any time?
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal.
You got it.
My name is Timothy Weber. I'm here on behalf of the appellant Christopher Burke, and we are seeking a reversal of the trial court's final judgment, in particular the permanent periodic alimony amount that was awarded based upon the trial court's refusal to impute income to the wife, appellee herein. The wife's testimony was that she worked 20 to 25 hours biweekly, so 10 to 12 hours a week, seasonally, and that this was the employment she was content with, notwithstanding the fact that she admitted to the vocational evaluator and testified in open court that she was capable of working full-time. In fact, not only did she testify she was capable working full-time, but she simply said she preferred to work part-time. Not only did she prefer to work part-time, but she made no effort since the dissolution proceeding began to look for other employment. And that was undisputed in the record. In fact, the vocational evaluation that was conducted, she told the vocational evaluator, "I haven't looked for other employment. I like what I do."
And
How
Mr.
did the
Weber,
wife?
she had been doing that for what, 14 years, I think the record said?
Correct. So the parties had two minor children before the dissolution proceeding began. And when the second of the children began preschool, in essence, she began working part-time. So this part-time employment began like 2004, and by the time of filing in October of 2017, she was still employed. But the critical distinguishing factor here was her testimony was that part-time employment, the advantages of that were so she could stay home with her school-age children who were off in the summers and would be in school and come home in the afternoons. By the time the dissolution is filed in October of 2017, the children are emancipated. In fact, the youngest child is 19 and living with the husband. And so the entire rationale upon which part-time work was based for the wife, staying home with the children, working seasonally when the children are out of school, no longer existed, yet the trial court didn't even address that distinguishing characteristic. Simply said, well, this is her level of employment. I would submit to this court that this is not using your best efforts to earn more that you're capable of earning, which is the standard.
Well,
and so we know she's capable of
Mr. Weber,
earning more.
can I stop you again?
Absolutely.
Because I have to admit, I have a bit of a hard time with this notion of voluntary underemployment and using your best efforts. And let me give you an example, and maybe you can help, maybe you can articulate it in a way that I can understand it better. I was a federal prosecutor for 20 years. Loved my job, that's what I had done. But there was no question, I think, that had I gone into private practice, I could have made more money. But I didn't want to because I loved my job. I'd been doing it for 20 years, and that was just the amount of money that job paid. So was I voluntarily underemployed? If I had been going through a dissolution proceeding, would I have had to quit my job as a federal prosecutor and join a law firm and go into private practice to make more money?
Nobody's suggesting that, Your Honor. What I'm suggesting is working 10 hours a week when you're capable of working 40 is a far cry from what you're describing, a career that you expended in a particular job that you defined yourself by, you enjoyed what you did, and you were good at it and skilled and trained at it. Nobody's suggesting that we have to dictate the exact job that she takes.
But didn't the former wife testify? I mean, she had been doing that same job part-time for 14 years. and she loved that job. She was good at it. She enjoyed it. But that there was no evidence that that job was available full time. And so
So,
wasn't she in sort of the same position? I mean, that was the job she had, that was the job she loved, and that's what that job was.
not really, Your Honor, because she had 30 hours a week that were idle. If she loved that job and wanted to continue to do that, she's free to do that, but she could do something with the other 30 hours in her week, whether that's a second job, some kind of self-employment, something to contribute to her own support. Otherwise, we are creating a situation where somebody can simply set a cap and never be voluntarily underemployed by simply saying, I like what I do. And I don't think that's what the law provides. In particular, the Cushman case from this court sets out the standards pretty clearly. If you have a capability of earning more and deliberately and voluntarily choose not to do so, that's what voluntary underemployment is. It's not that there might be a superior job or a superior opportunity that we're going to force you to switch to, but this is literally seasonal, 10 hours a week employment for somebody who is capable of working full time. And I don't think that the law is designed to promote idleness and to promote someone not using their best efforts intentionally. And we know that's the case, as in Slagle, where the vocational evaluator comes up with a list of possible careers and jobs, and the person takes no opportunity to explore any of that other employment, to consider any other opportunities available to them. In fact, the vocational report in this case at page 903 of the record lists clerical positions. She previously has a history of clerical positions that she has done before, file clerks, record clerks, office work, office management. All of these things were things the vocational evaluator listed that provided opportunities for full-time employment at significant rates of pay. And these jobs were available. The labor market data that he provided clearly set forth how these opportunities were available to her. In addition, teaching. She has a 4-year degree in elementary education because of the teacher shortage. The testimony was that she could simply ask for a temporary teaching certificate if she passed a background check, and she would have 3 years before she even had to get a permanent teaching certificate, which was simply an aptitude test. He gave her an aptitude test, and she scored the highest score that you could score on the aptitude test administered by the vocational evaluator. And so here we have a situation where we have somebody that was full-time employed for 13 years prior to the marriage and during the marriage. She worked for U.S. Airways from 1986 to 1999. And she left that employment. Principally, the husband testified as he didn't want her to fly anymore. It wasn't that he didn't want her to work anymore. He didn't want her to fly anymore because the flying was a stress on the family. But she left when the children were tender years. And basically at the point in time the kids went back to school is when she took this employment, the convenience of which was for the children. And that's the point that I think the trial court has overlooked here, in that we can't close up this record and say this is a fair result when she took this underemployment or this minimal employment, if you will, because of the children. And now
Mr.
the
Weber.
children are emancipated. I'm sorry,
Yes,
did
Mr.
somebody-
Weber, that's a great segue into a question I had about the fairness here, what you're talking about. One of the issues or challenges that I'm struggling with a little bit in reviewing this case, it's not raised as an issue on appeal, but it's nevertheless a challenge, is that it doesn't look like the final judgment contains any findings of either party's net income, right?
Yeah, I did allude to that in my brief, that the findings regarding the income and expenses of the parties were absent. It was simply a conclusion that $2,500 a month is what the wife needs. And so, yes, we didn't raise it as a separate point, but I did allude to the fact that this alimony award was just a number that was assigned. I don't know if it's the Goldilocks method or whatever that was used to arrive at it, but
Well,
essence.
for your purpose, that for your advocacy, I think it poses a little bit of a challenge because I'm looking through the transcript where the husband talks a little bit about how he doesn't seem to have the firmest grasp on what his net monthly income. It looks like he's got a second job. He does a lot of overtime, which is not uncommon at all. But it raises the issue, between looking at the W-2 stubs and the tax returns that were filed that were before the court, and given how much he was making, which looks like at least gross was in excess of 100K a year, is this really a situation where even if we were to impute income in the way you suggest and put 52K in her column for income, would it really be beyond the parameters of reasonableness under Canacaris for a $2,500 monthly alimony award?
Well, I would only say this: if the trial court's finding is indeed that her unmet need is $2,500 and you increase her income, then it would be, because at $52,000 a year, her level of income would be sufficient to meet all of her need. And so to award alimony in excess of...
So you would go for the home run. We go from permanent alimony. She's not entitled to anything.
So all I'm suggesting is that the need she presented to the trial court would not justify a higher amount. You can't award alimony in excess of the recipient spouse's need. And so had she had more needs, there would have been an alimony payment from Mr. Burke as a result of his superior income under that scenario. But she simply did not present any.
But I have no way, and this goes full circle to the question that I kind of led with. I have no way of knowing that without that finding of what her net monthly income was, right?
Well, you do, because you have her financial affidavit that she presented to the court. And she presented a financial affidavit, set forth what her expenditures were, okay? And you get to the $2,500 number by taking her expenses per her financial affidavit and factoring in her income. And so if her income changes, then the transfer payment changes.
So we just accept the financial affidavit as if it were a finding of the family court?
Well, I would submit that the family court could not have found anything higher than what was on her financial affidavit, and that finding to be based on competent substantial evidence. And so when a party says, this is my need, okay, we can take that at face value. And if she has simply been producing more income, the amount of alimony or the amount of unmet need would be considerably less. We at least know on this record that if the court were to have found that she was voluntarily underemployed, that it would make a difference because of the amount of need that she said she had. And so I would submit that we have a situation here that at minimum requires a remand for a redetermination of alimony based on an imputed income, because to find that this is not voluntary underemployment, I believe simply erases the voluntary underemployment doctrine from the books. I mean, 10 hours a week is not something that someone can say, I'm using my best efforts. We didn't try to look for a job. We didn't try to look for a second job. We didn't try to do anything with the additional 30 hours a week that we have, notwithstanding our capability to work full time. She testified to that. She told the vocational evaluator she was capable of working full time. And she simply said, I prefer to work part time. Now, I don't know what voluntary underemployment is, but that seems to me to meet the definition on its face. And so I understand that she liked her job at More Health. Fine, keep your job at More Health. But get a second one, just like Mr. Burke. he has a second and a third job. And when we talk about fairness, I think that that has to be factored in. These parties are both at the time of trial in their late 50s.
Mr. Weber,
And
Mr. Weber, just to let you know, you're coming right up on your 5 minutes.
all right, thank you. I will reserve the balance of my time. Thank you.
Very good.
Judge Lucas, I don't know if you've noticed, but Judge Atkinson has not been able to ask questions because of his mic.
Yeah, it looks like we're having some technical difficulties. So I'm going to, forgive me for a moment, I'm going to shoot a quick email to our court marshal and just let her know that we're having a technical difficulty. And in the meantime, what I would offer is if it's something that can be fixed fairly quickly, maybe we can just hold off for a minute. But if it's something that maybe requires something more, we'll have to get creative. And maybe Judge Atkinson, if you can email me or text me any questions that you might have, we can at least get those out there. But gentlemen, please be patient with us just for a moment as we have some technical difficulties.
Judge Lucas, can you hear me?
Now I can hear you great.
Okay, thank you.
Judge Atkinson, would you like to ask Mr. Weber any of the questions you tried to pose earlier? I'm not going to charge it against his time since this was a court issue.
Well, I think we perhaps gave short shrift to what I thought was a prominent issue, which was the rate and the prohibition in the statute on imputing income at a rate that had never been earned or realized by the imputee. And I think, and I just you can comment, maybe I'll just make a comment and you can comment if you want, Mr. Weber, but there seems potentially to be a conflation of issues. Well, one issue is involuntariness. So we have, whether the underemployment, and then we have voluntariness. A lot of your arguments regard voluntariness, which, I'll be frank, since time is short, I think the voluntariness aspect seems to have been substantiated, but underemployment is sort of whether one is unemployed has to do with the proof you adduced regarding the potential for more, and then another layer is the way I read the statute, even if there was potential for more, whether it's permissible to impute at a rate higher than she's ever made. So I think the arguments that are getting conflated is the voluntariness versus the evidentiary support for whether it was possible. Now she could expend no effort to make more money, and if there was no possibility, or if that was barred by the statute prohibiting imputation in excess of what she'd ever made, the rate she'd ever made, then it wouldn't matter whether she had extended no effort. It wouldn't matter whether she was involuntarily underemployed because she wouldn't be underemployed. So I was going to go into the concepts I just described, but I think time might be a little short for that.
Mr. Lucas, Judge Lucas, I'll just use a minute of my time to address that because I do think that's important. So the court grappled with that issue in Hinton versus Smith. And it's an issue when one spouse is working part-time, and in Hinton, the resolution of that was simply to say, we take your part-time hourly rate and multiply it by 40 weeks. And that's not running afoul of the rule that
so the concept would be rate as opposed to amount. The statute doesn't say amount, doesn't say you cannot impute an amount higher than she's ever made, but a rate. And so if we accept that argument, that rate could be construed to include hourly rate. What evidence do you have that she could, and this goes to Judge Rothstein-Uickam's point, we can't require her to do something different. What evidence is it that did you adduce that she could do exactly what she was doing at the rate she was doing it for more hours a week?
So there was testimony that her particular job did not have full-time work available, but the vocational evaluation at 903 of the record sets forth jobs that she could do at rates ranging from $10 an hour to $17 an hour, for which she was fully capable and qualified, that would offer full-time employment. For example, file clerk positions, health educator positions, private school teaching positions.
You would concede that, and I don't recall exactly the facts of Hinton, but what it seemed to me that, if I recall correctly, Hinton, there was some evidence adduced that that the individual, the spouse, could do the same thing at the same rate for more hours per week. Whereas here, that's a pertinent distinction between the facts of that case and this, which is there's no evidence that she could, at the same rate, do the same thing for more hours per week.
Well, that's not accurate exactly. In the vocational evaluator report, it says the mean pay rate for health educators is $26 an hour, and there were jobs available in the market in health education.
Not with the same employer, but the same.
Not with the same employer, but in her same line of work. And again, under the court's decision in Solomon, we don't have to prove a specific job available to her when she's made no effort to look. And that's what this court's precedents say. And so when we put down evidence that she could make $26 as a mean salary in health education in the Tampa Bay market, and she has no effort whatsoever to look, I think it is not an unreasonable conclusion for the court to say $25 an hour is available to her on a full-time basis. Even many of the clerk jobs are 15 or 17 would make a considerable difference in her contribution to the support of the family. And that's what we're talking about here with voluntary underemployment. You don't get to deliberately choose not to contribute and demand a transfer payment. Thank you.
Ms. Atkinson, anything further?
Oh, no, thank you, Judge Williams.
All right. Mr. Williams, I'm going to give you a couple extra minutes since we had some technical issues and we're able to indulge Mr. Weber for a couple extra minutes. So please proceed.
May it please the court. Judge Lucas, your honors, I'm Gary Williams. I represent Maureen Kelly, formerly Maureen Burke, with regards to the husband's appeal. I would submit to the court for consideration this morning that it appears that the appellant is asking this court to look at the facts of this case and substitute its judgment for the judgment of the trial court. And obviously that's not the role of this court. The role of this court is to determine whether or not the trial court abused its discretion. And as was well known by the standard that's established in Conacris, if reasonable people could disagree as to the propriety of a particular result, then the court has not abused its discretion. Now, certainly there's a basis here for people to reach different opinions as to what would be appropriate in the way of alimony, or what would be appropriate with regards.
Can we circle back to the point that I made with Mr. Weber on the lack of findings about net income? I mean, if this were an issue of computing child support, that lack of finding would be reversal on the face of the judgment, right?
Well, Your Honor, I'm going to submit to the court for consideration the notion that paragraph 13 of the final judgment reads as follows. The wife sought permanent periodic alimony at trial under Florida statute 6108. The court has considered each of the factors included in the statute as subparts A through J, and the evidence and testimony presented as to the wife's need for alimony and the husband's ability to pay alimony. The court finds that the case is appropriate for permanent periodic alimony based upon the length of the marriage, the respective ages, the physical and emotional condition of the parties, as well as the income and financial circumstances of each party. And I would submit that that constitutes a sufficient finding as a fact.
It's not a finding. It's more that is basically a punchline. It's a conclusion.
Yes, sir, it is. But it indicates to this court that the trial court took those various factors under consideration and then made a determination as to the reasonableness of the alimony award.
Well,
is it a perfect?
At best, it indicates that the trial court was aware that it needed to take these into consideration, but it's kind of like, you know, if you were to liken our court to video replay in a baseball game, it's kind of like if the umpire that we're reviewing unfortunately got in the way of our seeing the play on video, right? I mean, if we don't know what happened, like what it was he ultimately concluded, what it was that or excuse me, he in this one, what the findings were on the income, we have no way of seeing for ourselves. Yeah, this is within the boundaries of Canacaris as far as, what a reasonable jurist would come up with. I'm looking through the evidence that was put forward in this case, and as is not uncommon, there's variances, there's differences, and I don't know where the trial court ultimately landed on this. So help me out with that aspect from the point of view of the appellee.
Understood. And, if the judgment were rewritten, certainly it could have been rewritten in a better way with regards to the specific findings of fact that the trial court finds that the husband has this level of income gross, this level of income net, and then we have this number for the wife, and then we have the need of this amount for the wife as well. But the appellate court does have as part of the record the financial affidavits filed by the parties. As Judge Lucas noted earlier, that indicates that there's a substantial disparity in the income of the parties. And that being a part of the record, I think this court can conclude that there's a sufficient finding of fact in the court's final judgment to allow it to affirm the decision of the court. Additionally, as the court pointed out earlier, this matter is not up on appeal. So from that perspective, I understand the court's frustration with the lack of numbers. But by the same token, if you go to the next paragraph in the final judgment, the court notes that it did a line item review of the evidence regarding the wife's most recent financial affidavit, and that there are things included for which she is not going to have to pay after the sale of the home, meaning the marital home that she resided in during the proceedings. Well, this is clearly the wrong standard. The standard isn't how cheaply can the wife live post-divorce. The standard is what was the standard of living during the marriage. Now, the court got practical, if you will, and said, well, nobody can live to that standard, so let's see what the wife really needs in the future. But nonetheless, it is not the proper standard for the trial court to have utilized in that sense. So,
well, but
in
computing alimony, it is appropriate, and indeed it has to consider what the equitable distribution will be, right? And the marital home is subject to distribution.
And it also has to consider the financial capability of the parties to maintain the standard of living after the divorce. No question. I agree with the court completely on that issue.
Mr. Williams, I was going to pose a hypothetical. I thought Judge Rusty Newcomb's hypothetical was very instructive, but I want to pose a different one as a foil and ask you about it. Let's say that the spouse to whom income was asked to be imputed was a lifeguard, and that spouse had been performing part-time lifeguarding for the duration of the marriage. It started when the kids were in the home. The kids are out of the home now, and the going rate is $15 an hour. And there are I don't know how many country clubs in the area or beaches, but the other spouse adduced evidence that there was plenty of work out there for a lifeguard who wanted to pick up extra shifts. And under the Hinton case, Hinton, I think, this court, at least in that scenario, construed the statute prohibiting a rate higher than what was earned prior to not to preclude additional hours for an hourly rate employee. What would be the problem? Why wouldn't that be deemed underemployment? And why wouldn't the court be required to impute the income that the individual could have earned? And why is that any different than this scenario?
Well, there's a number of distinctions, Your Honor. First, I would like to talk about the Hinton case that was made reference to earlier by Mr. Weber as well as Your Honor. Hinton includes a ruling that says the attainment of a degree alone does not guarantee employment or a particular salary, and thus does not constitute sufficient evidence to support imputation. That's at 1157 of the case. Now, the point of that is that Mr. Weber and the appellate are not asking this court to ask the trial court to impute income at $25 an hour, because there was no evidence presented at trial that that rate would have been available for 40 hours a week. Instead, the appellant and Mr. Weber are saying, but the Vocational evaluator said that she could earn $17 an hour or $10 an hour in these other job functions for which she is qualified by virtue of the fact that she has that degree. But having the degree, especially a degree that's 35 years old and has effectively not ever really been utilized, at least not in the manner for which one might have expected it to be utilized, is really not a fair standard for us to assess future income earnings by the former wife.
So are you?
Hinton also says,
Mr. Williams, are you saying
I'm
that
sorry, Your Honor.
Are you saying that the appellant's argument is more akin to saying, well, she could have made this much money as a lifeguard, but she could have gotten full-time employment as a swim instructor? Are you?
I would think so, Your Honor. Yes. Now, one of the reasons that trial courts have as much discretion in the area of alimony as they do, and the overall body of work of the appellate court clearly indicates that the trial court has a great deal of discretion in this area, is because every situation is factually unique from any other. Mr. Weber made reference to Schlegel in his brief and in his argument this morning. In Schlegel, during the term of the marriage, towards the end of the intact marriage, the wife went and got a law degree and then said, well, I don't want to practice law, so don't impute income to me at that level. Well, now clearly within that confines of that fact pattern, it would be appropriate for the case to say, you have the ability to make a whole lot more money than you did during the marriage because you went and obtained this law degree recently.
Right, well, there's a statutory provision too. It says never earned in the past unless recently degreed, licensed, certified, relicensed. But I want to know what your perception of the facts adduced in this case are. Are you saying that there was no evidence adduced that the former wife could do the same thing she is doing and has been doing for these many years, more hours during the week?
There was no evidence presented at trial to support that argument.
What about?
There was evidence presented. I'm sorry, Your Honor. There was evidence presented at trial that said she could work more hours, but not at that $25 hourly rate.
Okay.
It would have been a reduced hourly rate.
And that segues perfectly into what I wanted to ask, which is there any evidence anywhere in this record that the former wife exerted an effort, any kind of effort to obtain or find full-time work of any kind?
During the term of the marriage, Your Honor?
No, post-separation. No, there's not. So it would be accurate then to say, for purposes of the making the best faith efforts, your position would be no effort need be made to obtain full-time employment if you've only ever been a part-time worker post-separation and post-divorce. Is that your position?
No, that's I don't think you can make that rule uniform to all cases. I think that's, again, a matter of discretion for the trial court. What are the circumstances in this particular case?
I'm not sure it's discretion of the trial court because the statute says shall impute to an unemployed or underemployed parent. So if the other spouse adduces evidence, competent substantial evidence that she's underemployed or unemployed voluntarily, the income shall be imputed, and unless there is an exception, which is may refuse as set forth below, one of which includes the exception at issue here, which is at a level never earned in the past. So I'm not sure, from my perception, how much discretion a court has once if a showing has been made that she is underemployed.
Well, I don't think that showing has been made, Your Honor. At least.
Okay. Well, then let's go. Let's hear that argument.
Well, let me respond to the court's question a little bit more thoroughly first, Your Honor, if I may. In Castaldi, 968 Southern 2nd, 713, which is a Florida 2nd DCA case from 2007, with which I'm well familiar because I lost the appeal in that case. The court said best efforts must be used to find a job for which one is already qualified. Now, the vocational report in this case was replete with information about jobs that my client was qualified to obtain if she went and got certain other certifications.
Well, let's stop right there for a second. Can I stop you right there for a second? because if we're talking about
Yes, Your Honor.
facts, which we've asked you to do, it is whatever. Yes, it has. There was evidence that for instance, the public sector teaching positions would require at some point a certificate, even if not immediately. But there was also evidence adduced that there were teaching positions that didn't require certification at all at private institutions.
Well, there was testimony by the vocational evaluator that in his opinion, private schools did not require that certification.
Right. So there was no countervailing
requiring
that to that, right?
Well, not requiring the certification does not mean they're going to hire someone without it.
But there was an
In this
expert
instance, we're
that
talking
said
about
he thought she'd get hired.
We're talking about a 59-year-old female who's never taught other than on a part-time basis for these Healthmore courses that she was teaching on and Mr. Weber refers to it as seasonal. Actually, it was based upon the school year because these were school programs that they were teaching. Who's now going to go apply to a private school that doesn't require a certification, but the vocational evaluator had no basis to assert that she would likely be hired by one of those institutions based upon the skills that she had. He merely said she wasn't automatically disqualified because she didn't have the certification.
That's going to be true of all vocational evaluation reports, right? I mean, unless
Yes, sir.
unless the evaluator, makes the extraordinary effort of actually obtaining a job offer to the person, which I don't even think they're allowed to do that. But that would be the only exception then. Otherwise, what you're saying is basically vocational evaluations cannot be, they're no good. You can't rely upon them in trial court because there's not sufficient basis to conclude that all of these jobs that the vocational evaluator identifies within the scope of the test, within the scope of the credentials and the test that the person has indicated they're qualified for, that this list is actually in any way accurate.
I agree with the court. If you extend the logic to that extent, yes, that's true. But in this instance, the vocational evaluator did not testify as to the skill set in particular that private school institutions hire. He didn't indicate whether or not a person who had no teaching experience could be hired by a private school institution. He merely said, well, she's not disqualified based upon this lack of credential. But that's not the same thing as saying she is likely to be hired by this institution because they hire this type of person. Now, we know what the public school system does in the way of hiring, because that's all pretty much public record. You got to have a degree, you got to be certified, you got to do all these things. The private school area is much less public, if you will, but the vocational evaluator did not present any evidence to the court from the appellee's point of view that said, yes, it was likely she would be hired by a private school given her particular credentials and experience. Now, if I may, very quickly, because my time is running short now, I want to talk about the other issue that's up on appeal that we haven't had a chance to discuss yet today, and that is the valuing of these financial accounts by the court that the appellant says should not have been distributed as part of equitable distribution because they had already been divided by the parties at a prior point in time. I'm going to make reference to Richardson v. Knight, 197 Southern 3rd, 143, which is out of the 4th DCA in Florida. It says that the court ruled that when there's an oral marital settlement agreement entered into on the record, that there must be clear understanding of the finality of the agreement, and the parties must affirm their understanding and unequivocal agreement. The court must confirm that each party has discussed the marital settlement agreement with their attorney, if there is one, and that they understand its terms and conditions. Now, if that's the standard for a settlement agreement announced in a courtroom, how can we possibly say that two parties get together and say, we're going to divide this checking account in half, constitutes a settlement that should result in the exclusion of those funds from the equitable distribution schedule? I would submit as a matter of public policy, that's a very dangerous precedent, because lawyers will soon be advising their clients, at least the husbands, go split those accounts up. Yeah, let's get out there and be getting the wife to take her half. And then we don't have to pay any support And if she diminishes those accounts to pay her own support, then we don't have to equitably distribute or make the adjustment in equitable distribution because of that dissipation. That would require the trial courts to ignore Roth, Zakora, Baer, and its prodigy of we don't distribute funds in equitable distribution that were used to pay the living expenses and litigation costs of an individual during the proceedings of the divorce. And with that, unless the court has something else for me, I am done.
All right. Thank you, Mr. Williams.
Thank you, Your Honors.
Mr. Weber, go ahead.
Thank you, Your Honor. I would just note specifically at page 905 of the record, the vocational evaluator had reached out to several private schools, Admiral Farragut, 2 or 3 Christian schools, Shorecrest, etc., and detailed jobs available in the community. And of course, Ms. Kelly has a Christian background. She could apply for a job at one of these private Christian schools. But again, under Solomon, when you make zero effort, it's not the husband's burden or the payor spouse's burden to prove that there's a job exactly available that that person could walk in and get tomorrow because she made no effort. But again, the data was provided from the job market, from the available jobs to the trial court. In addition, it wasn't just teaching, but it was the whole panoply of positions that were available to her on a full-time basis. She had worked as an office clerk. When she had worked for US Airways, again, talk about what she'd ever made, she made $2,965 a month back in 1999 and then in the 80s. And so she had the highest aptitude on the test given by the vocational evaluator. She is a smart woman, she has skills, and she just chooses not to have full-time employment. And even if she wanted to keep her lifeguard job, her More Health job, whatever job that she felt was important to her and fulfilling, that doesn't mean she couldn't go out and do more to contribute to her own support. She didn't try, and it's not fair to make Mr. Burke make up all of that shortfall while he has to work more overtime shifts and a second and third job. Thank you very much. I would ask the court, and just as it relates to the accounts, again, these parties both testified in open court. We met at the bank and we decided to split the savings account, 35 to him, 35 to her, at the time of their separation. They both acknowledged in open court that that's what they did. And yet, when we get to the end, the accounts are distributed, date of filing on the husband's and date of trial on the wife's. And the fact that she claims, well, you can't do this as depleted assets, that's not what happened here. The parties agreed to make a division of that account, and it should have just been
Mr. Weber,
taken.
didn't the former wife testify that she agreed to that only because she was afraid if she didn't, the former husband was going to take all the money out of the account?
She agreed to it, Your Honor. I don't know what to make of the fact that you agree to something and then go back and take a contrary position in court. She admitted she agreed to it. She admitted that's what they did. And they both relied on that by putting their post-filing earnings in those accounts. And so we ended up distributing Mr. Berg's post-filing earnings. And as far as the wife was concerned, the record was that her needs were fully met during this litigation. So I would submit to the court that distributing that account at date of trial values and taxing the former husband for his post-filing earnings was just inequitable under these facts. Thank you.
Thank you, gentlemen. You all may exit.